My name is Professor Y.S.R. Murthy. I am the Executive Director for the Center for Human Rights Studies, O.P. Jindal Global University. In this paper on national mechanisms for protection and enforcement of human rights, we will take up today the module on National Commission for Denotified Nomadic Tribes. We have already seen the National Commissions for Human Rights, Women, Minorities, Scheduled Castes, Scheduled Tribes, Protection of Child Rights, and also the Office of the Chief Commissioner for Persons with Disabilities, the Central Information Commission, and we have taken up the structure, functions of these bodies and also their powers. Today, we will examine what are these denotified nomadic tribes, what kind of violations do they face, and what kind of protective mechanisms are there to protect their rights. What are the learning outcomes? At the end of this module, you will be able to learn the historical context relating to the denotified, nomadic and semi-nomadic tribes. This module also seeks to make you aware about the repealing of Criminal Tribes Act of 1871 and the subsequent legislative developments. You will also understand the structure, role and activities of the National Commission for Denotified, Nomadic and Semi-Nomadic Tribes and to critically examine its achievements. Now, who are these denotified and nomadic tribes? They have their roots in colonial times. During the British rule of India, some communities were branded as born criminal. In fact, this kind of a branding it has interesting roots. T.V. Stephens, an influential member of the Law and Order Commission, noted that the prevalence of caste system is based upon the nature of profession and concluded that there are some castes which are professionally criminal. In 1830, the colonial government appointed William Henry Sleeman to prepare a list of instances of assaults on wayfarers in central India. The list of the assaults made the basis of Criminal Tribes Act of 1871, which notified several tribes as criminal communities. In this regard, Birender Pal Singh commented that the imperial rulers also could not understand the meaning of nomadism, for instance, which was a way of life with a large number of communities in India and outside. It was not only a lifestyle, but also a philosophy of life. Why stick on to a place? Why change nature and intervene its practices? Thus, you have some class of people and communities who lived with and in nature and practiced nomadism, and these people were misunderstood by the imperial rulers and administrators and were branded in a negative manner, which gave rise to continuing human rights violations. This step was taken by the British government to maintain the law and order after the India's first war of independence or mutiny of 1857, and there were threats coming from some of these communities. It was one of the brutal acts passed by the British government. The people of these communities were not allowed to leave their native place. The Criminal Tribes Act restricted the movement and the any breaking of rules of this Criminal Tribes Act resulted in severe punishment. In 1908, the Act was modified for providing the prisoner from a criminal tribes community rehabilitation and reformation. Though the settlements were meant for reformation, for all practical purposes, they were jails. This Criminal Tribes Act was further modified in the year 1911, but no major change took place. In 1924, the Act was modified to facilitate the process of integration of the criminal tribes with mainstream, but the basic tenets of legislative purpose remain the same. In 1937, the Governor of Bombay Province appointed a committee under the chairmanship of K.M. Munshi to review the Act. This committee, in its report for the first time, defined various terms like tribe, gang, class, habitual offender, criminal, and so on. This Act was repealed by the government of Bombay in the year 1949, while the Madras government had repealed it in the year 1948. In independent India, the Criminal Tribes Act 1924 was repealed by the Criminal Tribes Laws Repeal Act of 1952 on the recommendations of the Sri Ananthasayanam Iyengar Committee. As a result, the tribes notified earlier on as criminal tribes stood denotified, and the name denotified tribes has been in use for them since then. If you look at the official website of the National Commission for Denotified, Nomadic and Semi-Nomadic Tribes, it also describes the account of further developments with respect to these tribes. In the year 1953, the Kalelkar Commission was appointed. It suggested that the tag of ex-criminal must be scrapped from the tribes and they could be called denotified communities. In 1965, the Lokur Committee, constituted for the revision of scheduled castes and scheduled tribes lists, which suggested that due to small numbers of the denotified tribes, the development schemes usually designed for scheduled castes and scheduled tribes have not benefited them. Hence, their inclusion in a distinct group was suggested with development schemes specially designed to suit them. In 2002, the National Commission to Review the Working of the Constitution, headed by Mr. Justice M.N. Venkatachalaya, submitted its report to the government recommending to strengthen programs for the economic and educational development of denotified tribes, which paved the way for the constitution of a separate commission to look into their needs and grievances. This commission was constituted and it came into existence, and it did some work in the year 2005. In addition, the National Advisory Council constituted a working group on denotified, nomadic and semi-nomadic tribes in 2011, which also proposed a detailed set of recommendations for these communities. Now, what is the context? If you see, these denotified tribes are present in varying concentrations in a number of states. In absolute number, the population of denotified, nomadic and semi-nomadic tribes put together is over 8 crores. In Delhi, Gadiya Lohar or Gaddi Lohar and Sansis live, while in Gujarat, Bahurupis, Chamtas and Sansi, Chara communities live. In Maharashtra, Banjara, Ramoshi and Pardi tribes live. Each denotified nomadic tribes community is an endogamous group. Though they are termed as tribes for all practical purposes, they were treated as castes in their traditional rural society. Restrictions on interdining, intermarriages prevailed. They were not considered untouchables but occupied lowermost positions in social hierarchy. They are mainly patriarchal communities. The authority of elderly males is considered supreme. The status of women is extremely low and very often brutal sanctions are imposed on them. They have a very strong caste or tribal council. Almost all decisions pertaining to their domestic and social life are negotiated in caste council. Nomads are people who are constantly on the move and have no permanent home. On the other hand, semi-nomadic groups tend to have a fixed habitat for a part of the year and are on the move in the rest of the year. The people have strong ecological connection. Many of them are dependent upon various types of natural resources and carve out intricate ecological ties for their survival. Now let us turn our attention to the kind of human rights violations faced by members of these communities. The Criminal Tribes Act was revoked in 1952 and the notified communities were denotified. The Criminal Tribes Act was replaced by Habitual Offenders Act. It is very important to recognize the fact that the Habitual Offenders Act targets individuals and not communities. However, in actual practice, the police department, still molded in the colonial tradition and mindset, often follows the same old practices. This is the major and practical implication of the Criminal Tribes Act. The police department still does not accept the fact that the whole community cannot be branded or stigmatized in this manner. Further, the attitude of the general public has not changed and they are still considered as criminal and thus face human rights violations. Following their branding as habitual offenders, members of these communities face instances of mob lynching, arson, police brutality, police high-handedness against members of the erstwhile denotified tribes. The National Human Rights Commission in its annual report for 2001-2002 noted that though the Criminal Tribes Act 1871 was annulled soon after independence, the police as well as members of the public frequently and most regrettably continue to treat persons belonging to these communities as born criminals and habitual criminals. They therefore remain amongst the most disadvantaged and most discriminated against in the country. These tribes have not been classified till date. Except some, they have not found place in the categories of scheduled tribes, scheduled castes and other backward castes, depriving them from the benefits given to these categories under the Constitution of India or under any law. For example, many of these communities have not been protected under Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act of 1989. As a result, the violation of human rights cannot be addressed effectively. As an eminent academic G.V. Devi noted, I quote, "Being illiterate and ignorant of the law of the land, the denotified tribes know very little about the police procedures and so often they get trapped in difficult situations. The onus of proving their innocence rests with them," unquote. People are scared to wear new clothes for fear of being arrested and therefore soil them before using them. Mob lynched, hounded from village to village, starved of all civic amenities, deprived of the means of livelihood, and gripped by the fear of police persecution, the denotified, nomadic, and semi nomadic tribes of India are on the run. Freedom has not still reached them. Hence, they remain amongst the most discriminated and disadvantaged groups in the country. After the death of Budan Sabar, a leader of denotified tribes in police custody, one public interest litigation was filed by Mahasweta Devi in Kolkata High Court. On August 6, 1998, Justice Ruma Pal passed an order for conducting a CBI inquiry into Budan Sabar's death. The inspector Ashok Roy was immediately transferred and a sum of rupees 1 lakh compensation was awarded to Budan Sabar's widow. Now let us examine the role of National Human Rights Commission in this regard. The NHRC took up several individual instances of police high-handedness against members of Pardi tribes in Maharashtra and recommended compensation to them. The commission constituted an advisory group headed by an eminent person, Sri B.D. Sharma, who was the former Commissioner for Scheduled Tribes, to examine issues pertaining to members of denotified, nomadic and semi-nomadic tribes. This committee, in its report, which was submitted in August 1998, made several important recommendations to improve the condition of these communities. Following are some key recommendations. A retired senior police officer of high reputation may be appointed in every state by the NHRC to watch the cases of atrocities against denotified communities and report them to the Commission. Where there is a concentration of an old settlement existing, a separate officer may be appointed at the district level. Since the police training is still faulty in this respect, the National Police Academy and other police training institutions may be advised to reorient their syllabi. It was also recommended that NHRC may take necessary steps leading to the repeal of Habitual Offenders Act. Central and state governments may be directed to make proper enumeration of these denotified nomadic communities, and these communities may be provided educational, employment, other infrastructural facilities. The state governments may be asked to work out action plans for denotified communities with specific provisions in the plans. The Planning Commission may be advised in this regard. And it was also recommended that a massive information campaign aimed at bringing about a change in the general attitude, mindset against the denotified communities. The National Sample Survey Organization should be directed to make a special survey of the socio-economic conditions of the denotified communities. The National Human Rights Commission accepted all these recommendations and asked all state governments to take necessary steps and thereafter monitored the implementation of these recommendations. Now, let us look at how the current commission came to be constituted. In the year 2015, the central government felt, after reviewing the reports of earlier commissions, it was felt that there is a need to constitute a new national commission to focus upon identification, inclusion, status, area of habitation to review the progress of development of denotified nomadic tribes. The commission started working in 2015 under the chairmanship of Sri Bhikkhu Ramji Idate. What is the composition of the commission like? The National Commission for Denotified Nomadic and Semi-Nomadic Tribes comprises the following, with Sri Bhikkhu Ramji Idate as chairman, Sri Shravan Singh Rathod as a member, and Sri B.K. Prasad, a former Indian Administrative Service officer, as the secretary. What are the terms of reference of this commission? There are a series of terms of reference laid down. This commission is required to prepare a state-wise list of castes belonging to denotified and nomadic tribes. It was required to identify the castes belonging to denotified and nomadic tribes in the lists of SCs, STs and central list, state lists of other backward classes. This NCDNT was required to identify the castes belonging to denotified nomadic tribes which have not been included in the lists of SCs, STs and central lists of OBCs, and to pursue their case for inclusion in these lists depending on the modalities laid down for such inclusion. The commission was also tasked to evaluate the progress of the development of the denotified and nomadic tribes under the union and the states. It was asked to identify the places where these communities are densely populated and suggest appropriate measures in respect of denotified and nomadic tribes to be undertaken by the central government or the state government concerned. Its functions also include any other tasks that could be assigned by the Ministry of Social Justice and Empowerment. And in pursuance of these terms of reference, this commission undertook many activities. The National Commission for Denotified, Nomadic and Semi-Nomadic Tribes undertook visits to the states, met community leaders belonging to these groups, researchers, non-governmental organizations, besides holding more than 20 regular commission meetings since September 2015 to check out its agenda and program of action. The National Commission held meetings with the representatives of the various finance corporations for scheduled castes, backward classes, Safai Karamcharis and scheduled tribes. The idea behind these consultations is to organize the power of these corporations and the schemes of these corporations for the benefit of the denotified and nomadic tribes communities. The commission also has made a number of short-term or interim recommendations so that appropriate development action for these communities can be initiated without waiting for its final report at the end of its 3-year tenure. In particular, NCDNT recommended the formation of district level grievance redressal committee headed by the district magistrate. It recommended establishment of a directorate for denotified and nomadic tribes to check out programs for their development and allocation of budget on the lines of Maharashtra model. Constitution of a corporation or a board for the development of the denotified tribes and nomadic communities on the lines of Gujarat model. In addition, the National Commission has constituted a number of subgroups for the preparation of policy papers and recommendations on the following areas. For example, housing scheme on the lines of Gujarat, reservation of seats for denotified tribes and nomadic students in hostels constructed for SC, ST, OBC communities on the lines of that is what is being done in Karnataka, allow the produce of denotified tribes and nomadic communities to be marketed in economic hubs for SC/ST communities. The National Commission for Denotified Tribes also has plans to take up the issue of conducting census for denotified and nomadic tribes communities with the help of the Registrar General of India Census for planning proper development programs and policies. The efforts of the National Commission for Denotified Tribes and advocacy have resulted in better, increased, enhanced awareness of developmental issues concerning members of these communities among various stakeholders. Finance corporations for SCs, backward classes, Safai Karamcharis and scheduled tribes, as a result of the lobbying, as a result of the advocacy mounted by the NCDNT, have set up goals in their organizations in respect of these communities. As a result, there is a speedy and sympathetic disposal of the benefits relating to the denotified and nomadic educational institutions. The achievements of the National Commission for Denotified, Nomadic and Semi-Nomadic Tribes include finalizing a work plan, methodology of research, preparation of state folder on denotified communities, strategy or action plan, constitution of working group or expert groups. In addition, it has made a number of efforts to generate awareness through publication of a brochure, pamphlet, CD and a booklet on denotified, nomadic and semi-nomadic tribes. A search for new hope and through material on its website. The National Commission for Denotified Tribes faced many teething troubles soon after it started functioning in January 2015. The challenges included human resources, office space and physical infrastructure. This commission requires full support in its work from the Ministry of Social Justice and Empowerment, Government of India, as well as other ministries at the center and departments at the states governments. In conclusion, once branded as criminal tribes, members of the denotified tribes faced stigmatization, prejudice and consequent human rights violations. Even today, they face many significant challenges. The National Commission for Denotified, Nomadic and Semi-Nomadic Tribes was established in January 2015 under the chairmanship of Sri Bhikkhu Ranji Idate. In this module, we have seen how there is a long way to go for protecting the human rights of denotified tribes. The Commission has to take appropriate measures in this regard and advise government of the day for robust financial assistance and make people aware to change their mindset towards the communities and must take steps towards the integration of the denotified, nomadic and semi-nomadic tribes into the mainstream by providing them proper opportunity of reservation and other positive action similar to the scheduled tribes, OBCs and scheduled castes. Thank you.